Hi, I'm Howard Spence. I'm Eaton County Commissioner from Delta Township here in the state of Michigan. And I wanted to share today some information that I received along with some of my fellow commissioner colleagues at the Eaton County Health and Human Services Committee meeting, which was held this morning in Charlotte, Michigan. And I should start out by saying that the information I share here and the views that I share here are my own personal views, and they are not necessarily the views or policy positions of any other Eaton County Commissioner, nor of Eaton County government generally. But I did want to talk to you today about an agenda item where we had a presentation from two separate law firms at our Health and Human Services Committee meeting. These firms were approaching Eaton County government, soliciting Eaton County to become a participant as a plaintiff in a civil litigation against some of the largest corporations in our country, Fortune 500 companies who are in the pharmaceutical manufacturing and distribution businesses. And the reason for the law firms to come was that they are presently out as a part of a collaboration or consortium of law firms across the country, and particularly here in the Midwest, which are initiating civil lawsuits against these large pharmaceutical companies, alleging that they broke laws relating to the manufacture, sale, production, or marketing of certain opiate drugs, which are potentially very addictive and which have ravaged the central part of our state and also our neighboring states, including states which have been particularly hard hit as of this time, such as Ohio and West Virginia. In fact, I have myself written 3 or 4 extended articles relating to the opioid or heroin overdose epidemic, which is now impacting Eaton County, our neighbor Ingham County, and several other counties in central Michigan. And the articles I wrote on the opioid and heroin overdose epidemic can be found online in an archived electronic file format on the website maintained by the New Citizens Press newspaper. And if you're interested in getting some background from my perspective about this opioid epidemic here in Michigan and throughout the Midwest, you can go to the website of the New Citizens Press newspaper, which is www.tncp.net. And once you're there, just search for Howard Spence or opioid, and you should be able to come up with all 3 of those articles. And hopefully that would be helpful to you if your interest is in that area. But in any case, the opioid epidemic, overdose epidemic, has really had an impact not only on the lives of many of our residents throughout the state of Michigan and even here in Eaton County, but it's had a significant financial impact on governments, particularly local governments such as Eaton County government or Ingham County government, because we have responsibilities to maintain certain aspects of public safety, public health, to deal with people who are addicted or becoming addicted to heroin and opiate drugs, to provide for their treatment and protection in some cases. And this could be very, very expensive, not only in terms of taxpayer dollars that are used to fund the programs that would help with the treatment or rehabilitation or even saving the lives of our residents. Like I said, very costly, both from a law enforcement, which is a public safety perspective, and also from a community health perspective, where we are approaching this problem, this epidemic, as though it were in fact a public health condition. And in fact, even at the national level, it's really recognized this is one of our major issues that we need to confront at the present time. And President Trump even went so far as to declare that it was a public health epidemic or menace a week or two ago. But in any case, these two law firms were here today to help educate me and my fellow commissioners who are on that Health and Human Services Committee meeting about the dangers of the opioid epidemic, but also to let us know about ongoing litigation which has been beginning and in fact in some cases filed within the past 6 months to a year. And those cases are popping up all across the country. And one of the reasons that it is important and interesting from the perspective of a county commissioner is that these particular lawsuits, which are civil lawsuits, are seeking cities and local governments and counties to be plaintiffs seeking to recover our costs, which we attribute to the addiction and overdose epidemic. The theory being that many of these expenses and costs that are now imposed on government and which are ravaging the lives of so many of our residents were costs or detriments that the pharmaceutical industry was well aware of, and that in the past, in order to sell as many of these opioid drugs as possible, they either misinformed the physicians who were prescribing these drugs in very excessive amounts, or were knowingly setting up a scenario where they are making money at the expense of our residents and people becoming addicted to drugs, which could have a significant adverse and continuing impact on their lives for many years. And the two groups today that came were actually competitors in one sense, seeking to not only persuade Eaton County government to become a plaintiff in this particular litigation scenario, but also they were trying to make us understand the potential, the financial potential for recovery in litigation. And we listened to their presentations, and I had not anticipated that they would be there to make these presentations. It was something of a surprise to me, but it was a very interesting and informative dialogue. And so I decided to video record on my video cell phone camera some parts and aspects of the presentations of both these groups and to share that online. First of all, for the benefit of those other commissioners in Eaton County who are not on that committee, who may not even be really aware of the opioid epidemic and the overdose death costs to our county, but also to members of the public so that they could get a better idea of how government works. And at the committee meeting, obviously what these two law firms were seeking was to be hired on a contingency basis by Eaton County to represent their interests in a mass tort litigation, a big litigation against, as I said, several of the largest corporations in the country, much in the same way that a decade or two ago there was litigation against the tobacco industry whereby mass tort litigation, the states were able to get a settlement which brought millions and millions of dollars into government to be used to counteract the adverse consequences of the knowing bad acting of the tobacco industry. And we're kind of there today. The two groups today that were here informed us that some of the other jurisdictions right here in mid-Michigan have already signed on or are soon to sign on as plaintiffs in the lawsuits which are already being initiated as named additional plaintiffs. And they mentioned the city of Lansing, and they've also approached our friends and neighbors in Ingham County, and that outcome is still pending decision there. Some of the commissioners at our Health and Human Services meeting today were reluctant to become excited or to make commitments about becoming parties in this litigation for whatever reasons they might personally have. But a situation like this where there are known financial detriments to the county, where there are fairly obvious and clear marketing practices violations by the potential defendants, where there's massive amount of money involved in terms of profits made at the expense of residents and indirectly government. These situations, in my mind, especially given the fact that this would be contingency litigation where counties and cities would have no costs of litigation. This would all be absorbed on a contingency basis by the collaborations or consortiums of lawyers who are litigating these many cases across the country. But some of my colleagues were reluctant to indicate that they had an interest in this type of activity. I'm sure we'll be discussing it further over the next month or so as we look forward to determining whether or not we want to become involved as plaintiffs in these actions. But from my perspective as an attorney and knowing that I have certain fiduciary duties to my taxpayers and the voters and residents who I represent here in Eaton County, to me it's pretty much a no-brainer. No potential additional cost to the county, the possibility of significant recovery at some point down the road, whether it's 2 or 3 years or more. These types of things, I think, to protect the public purse and to punish or slow down wrongdoers is something that is pretty much a fiduciary duty for elected officials like me. So I'm pretty confident that Eaton County will become a participant in this broad-based litigation, which is pending consolidation. There will probably only end up being 1 or 2 trials on a nationwide basis. And we'll be joining probably the city of Lansing as litigants in one of the cases. We don't know which attorney and which group of attorneys. The attorneys there today who will appear on the video that I have appended to my statement were of 2 separate consortiums, and they left materials with us which are available to the public as public documents now. One law firm group is the Summer Schwartz Group, which is a Michigan company, a Michigan law firm out of the southeast Michigan area. And the other potential consortium of attorneys who would like to be able to represent Eaton County are spearheaded by the law firm of Weitz and Luxembourg. And they are also affiliated with and litigating as co-counsel with the Bernstein law firm, which is involved widely throughout the state and indeed I think nationwide on this type of litigation or similar types of litigation. And locally, the Church Weibel law firm here in the greater Lansing area would be their local council representatives. Our controller will probably be directed or authorized to issue a request for proposals, which is basically a document put out advising contractors, law firms who could possibly provide these services of our desire to get cost quotes and service quotes in the form of a proposal so that we would have a variety of possible law firms or partners in this litigation if our county decides to enter into this as plaintiffs. And of course these 2 law firms are only that are appearing on my video later are only 2 of potentially many. It's my understanding that Wayne County, some of the other counties in the state, have contracted or retained law firms other than the 2 who made presentations to us. But when all is said and done, we want to make sure that we have a very substantial law firm representative with longevity. This type of litigation is hardly cheap. The county itself, local government itself, would never be able to handle the litigation against some of the largest corporations in our country and indeed in the world who have such a large financial interest. So eventually, at some point in time, there will probably be several groups of attorneys involved in this mass tort action. And if everything worked out the way it potentially could, or seems like it might, at some point, maybe years down the road, long after I'm no longer a commissioner here in Eaton County, the people, the taxpayers of Eaton County would get some return on the tremendous amounts of money that they are expending now to deal with this opioid and heroin addiction overdose epidemic, which it seems pretty obvious has been stoked by the greed of some of the pharmaceutical companies who manufacture and distribute these drugs. Distribution in amounts, quantities way beyond reason, and it's pretty obvious that they, just like in the tobacco litigation of a decade or two ago, they know the consequences of their greed. They will become very, very wealthy, which they have, and our residents who are succumbing to their marketing pleas and entreaties and misinformation and deceit will suffer greatly. So with that, I'm going to encourage you, if you're interested, to take a look at these presentations. It may give you some additional insight into the opioid epidemic and also into how litigation occurs. Because as county commissioners, as city councilmen, as fiduciaries for the public trust, many of our most significant decisions are decisions that require us to use due diligence, to use risk management concepts, and to be willing to take litigation risks and efforts to protect the public purse. So with that, thank you for listening if you've gone this far, and if you have thoughts about this, feel free to contact me, your county commissioner, or whoever that you think is appropriate to voice your position. But like I said, short of some major revelation about a risk which I do not foresee or cannot anticipate from entering into this litigation, it's pretty much, in my view, a no-brainer that the Eaton County Board of Commissioners needs to select a strong, respected representative to help us get through litigation with a minimum amount of our own resources and time that could have potentially a very significant return for our residents, taxpayers, citizens, and you and me. So with that, have a great day, and if you have questions, as I indicated, bring those forth. Take care.
And the purpose of these lawsuits is to assist governmental units in two things: recouping the monies that have been expended to deal with the opioid crisis, and two, to set up abatement funds to deal with the problem going forward in an effort to curb the impact of opioids on our communities. And our consortium now represents over 80 counties and cities nationwide, many counties in Ohio, most of the counties in Kentucky, many counties in North Carolina, in West Virginia, in Pennsylvania. We represent the state of New Mexico. We represent the city of Cincinnati. The defendants in these lawsuits are the manufacturers and the distributors of opioid prescription drugs. And the theory on these cases is that the distributors and the manufacturers were well aware that thousands, millions of doses of opioids have been diverted into illegitimate markets. They the statistics bear this out, and I am going to have Lisa Esser particularize the national statistics in terms of Eaton County and the actual numbers of doses and pills of opioids that have flowed into Eaton County that far exceed what is necessary in order to actually treat individuals with chronic or acute pain. So the theories of liability with respect to the distributors, and there's three major distributors that occupy about 85% of the market. And these are enormous companies, Fortune 500 companies. And three of them have the market. And the theory of liability in these cases rests on public nuisance, also rests on a violation of the several different statutes regarding controlled substances that obligate distributors to monitor the number of doses that go into a particular jurisdiction. And if those doses exceed what would be normally expected, then those distributors have an obligation to notify the authorities, to notify the DEA. And in fact, all three distributors have been found by the DEA to be in violation of the Controlled Substance Act, and they have been fined, but many of these distributors consider these fines to be a cost of doing business.
We believe this is an effort that Eaton County should consider, engage in, and we're going to show you why, okay? So President Trump, as most of you know, declared this a public health emergency, 2 weeks ago now. The epidemic claimed 64,000 lives last year alone, and it's now the leading cause of death for those under 50 years old. I'm sure most of us know someone or know someone that knows someone that's been touched by this epidemic. Opioid sales in the United States has increased by 300% since 1999. While we in the US have 5% of the population globally, we consume 80% of opioids, just in the United States alone. In terms of Michigan prescriptions have increased 41% from 2009 to 2015, and they continue to go up. We rank 10th nationally in per capita prescriptions and 15th in overdose deaths. In terms of Eaton County, there's more prescriptions given in Eaton County than you have in population. For every 10,000 residents, there's 11,243 prescriptions written. That is an increase since 2009 of 44%. You're outpacing the state of Michigan as a whole.
That's opioid, right?
Opioids.
Okay.
When we're talking about opioids, we're talking about OxyContin, oxycodone, hydrocodone, morphine, fentanyl.
Right.
All right, the Schedule II substances under the Controlled Substance Act. And we pulled some data that you can get, and what I did, I spent the last few days last week just doing one quarter for you in Eaton County, and this is 2015. I don't know if you can all see it, but this is quarter one, 2015. These are the number of pills that were sent into this county in that quarter alone, and that was sent by Mr. Sickles, when you mentioned the distributors, McKesson, AmerisourceBergen, and Cardinal Health. They control 85% of the market. Then you have other pharmacies that kind of fill in here and there. So the other pharmacies that shipped into Eaton County were Kerr, Anda, Auburn Pharma, Meyer, and Quest Pharma. Total in that one quarter, 784,571 pills. That's in one quarter in 2015 in Eaton County. And the highest one on here was a CVS on South Cochran Road, 175,000 pills in that first quarter alone. Now, we have data for every quarter, but as you can imagine, it takes a lot of time to count the number of pills coming in. The data literally gives you day by day by day, the orders.
Excuse me, where did you get the data?
So we did this through a FOIA request for the state of Michigan, and what we got back were tens of thousands of pages. And this only gives us a snapshot. The data that you really need to pursue this litigation, it's ARCOS. It's a DEA system that the distributors and wholesalers have to report into. However, the companies have fought aggressively over the last decade and getting this data. It's not out there. The only data, ARCOS data that's out there is from West Virginia because it was leaked. And that's where you saw the first public nuisance case, which our conglomerate filed in West Virginia in February of 2015 this year when we got that data. And what that data showed us was the amount of opioids sold over a decade and how gross that amount was. And it also told us that they had never once reported a suspicious order. So for all the opioids that they were selling, McKesson, Cardinal Health, AmerisourceBergen had never once reported to the DEA that they were being asked to sell this gross amount of opioids in those counties. So in terms of, let's see, Eaton County, we know from CDC data in the year 2010, 169 pills were being prescribed per resident. In 2015, it was 178. So what does that mean, right? 169, 178. Well, the national average, if you go nationally, per person is 82. 82, so you're double the national average in this county alone. Sarah has some specific numbers that she also told.
I took a preliminary review of the data that Michigan has. They have their own controlled substance prescription monitoring program called MAPS, or the Michigan Automated Prescription System. And this program looks at all the controlled substances in Schedules 2 through 5, and they're all required to be reported in on a daily basis. This yearly reports are downloadable from the website, where you can look at each prescription drug and each script and each pill available in each zip code. So what I did is I took Eaton County and I took all the zip codes in Eaton County, and I looked at all the most commonly abused hydrocodone and oxycodone drugs. I looked at all the different variations of them, and I looked at the different versions of those, such as with acetaminophen and combinations of those drugs. I looked at years 2010 through 2016, and I looked at the combination of the pills versus the scripts versus the population. And when I looked at the total amount of oxycodone scripts and hydrocodone scripts, and then I looked at the amount of pills in 2010, 2012, 2014, and 2016 is all around over 5 million pills available in Eaton County for that year. So when you look at it compared to the population, you break down only the most commonly prescribed pills. It's like around 50 pills for every man, woman, and child in the county, which is it's an outrageous amount.
Those are just two types of opioids. The ones that people get addicted from, or the ones most heavily prescribed, I should say.
Are those mostly overprescribed in the rural areas of our county? You said you did it by zip code.
We do see that nationally, that the more rural the area, the worse it is.
Okay.
But here's the thing, there's a caveat to that, because we can go county by county pulling the statistics, but you're close to Lansing, you're close to Calhoun. People drive to see a certain doctor, a pill mill, maybe that's in some other out county, to bring get their pills and then fill it back here. So that's why you have to look not just at Eaton, but everything that's going on in the state of Michigan to really get a handle on it. So what this litigation is going to do, and I took a look at Eaton County and your activities, and I have to applaud you. You're one of the first counties in Michigan that equipped your sheriff's department with Narcan in 2015. And since then, your sheriff has these excellent reports he does week by week, and you've saved a number of lives on there from literally the deputies getting there before EMS arrived. And what this litigation is going to do is fund that in part, more training, funding the Narcan administration. And then you have a number of programs as well in the community that this can help with. And you have drug courts. You've instituted some of those things here, and again, that's going to help fund some of that and expand it. I looked at your budget for 2017, and it doesn't break it down by exactly what's going into it, but it's I'm sure that there's things in there that we would have to take a look at and figure out what are you expending as a county on this opioid epidemic, on the heroin epidemic, and now carfentanil. It's all just progressing. Thank you.
Epidemic, and it has recently been declared a national public health emergency. So the question is not whether Eaton County should do this, but really the question is who can best help Eaton County. And for those of you who don't know me, I grew up in Pennsylvania, Pittsburgh, where I became a pharmacist, practiced for a couple of years before moving to Lansing in 1981 to attend the Cooley Law School. I have lived in the Tri-County area for over 36 years now. I have been a lawyer handling complex litigation in the Tri-County area for over 34 years. I know Eaton County, so I would be your local liaison, the contact. As I've mentioned, the city of Lansing has already retained our services. We were successful in passing a resolution in Lansing declaring this opioid epidemic a public nuisance. The city of East Lansing has informally indicated to me they are interested in our group. We have presented to the Ingham County Human Health Services Committee, just as you folks are. We will be talking to Clinton County. I've already discussed this issue with the executive director of the Community Mental Health. I believe there's a strategic advantage for the 5 to 6 municipalities, 2 to 3 cities, 3 counties to have the same representation because of the overlap of some of the issues. Mark Bernstein of the Sam Bernstein Law Firm, as I said, is strategically situated to handle the statewide issues, and I've had a relationship with his law firm for over 30 years. Paul Novak with the New York national firm of White's Luxembourg, who happens to have a satellite office in Detroit that Paul heads up. I've done business with them on different drug litigations and product liability litigations for over 10 years. I attended the National Opioids Litigation Seminar in Washington, D.C. this past September. I met with all the players involved in this litigation across the country. I received offers from several of the groups. I believe our group of Michigan-based lawyers with the national-based law firm that I have direct access to is your and our best firms for this issue for Eaton County. And there's really no downside. We assume the risk to Eaton County, putting forward all the costs. It's going to be expensive. It's going to be a long-term commitment and a war. But we only get paid if there's a recovery for any of the expenditures that Eaton County has made unnecessarily for the misrepresentation, the fraud, and the deceptive marketing by Big Pharma and the national distributors. So I'll turn it over to Mark for a state overview, and then Paul will be able to give you the national strategic litigation.
Well, before you do that, if I may just ask questions.
No problem.
You mentioned our community mental health person. That's Sarah Lurie?
That's Sarah Lloyd. I've known Sarah for 30 years.
Right, and she is, in fact, heading a state agency. I guess CMH is a state agency rather than a local jurisdiction agency?
Well, it's a tri-county. It's the Clinton, Eaton, Ingham County.
Right. Well, I guess my question is, we're talking counties and cities here today. Is there a role, or has the state attorney general expressed an interest in intervening in that civil litigation?
The state attorney general has indicated that he is interested in joining 41 other bipartisan states attorney general in investigating it. He hasn't committed the state of Michigan at this point.
And at this point, are there any state level actions pending against these big pharma, as you describe it?
Not in Michigan. The only two counties that have filed thus far are Wayne and Oakland County.
Right, but nationally there are some.
There are states that have filed.
Okay, all right, thank you.
Thank you for your time. I don't want to take up too much. The last time I was here was for the Duluth Memorial Baseball Tournament for my son's travel team. I hope I have a better outcome today than I did this past summer in June. Thank you for your time. Obviously, this is a case that has both individual personal implications for many people. We've been making these presentations around the state to cities and counties, and every single time we make a presentation, either before, during, or after, someone at the table or in the room shares a very deeply personal experience with this exact issue. So this has personal, societal, and of course financial implications for every municipality, whether it be a city or a state that's involved in this. I also want to thank colleagues at Summer It's obviously a distinguished, successful firm, so I'm not going to repeat the information that they shared with you, which is obviously compelling. This is, I would add one thing though, there's no doubt that the list of damages that Rob laid out are recovery of costs, abatement funds, and I would also add a third, and I would assume this would be a part of their claim as well, would be some form of injunctive relief. In other words, saying to these manufacturers and distribution companies that the practices that have caused this circumstance need to stop. The marketing processes, the failure to report information to the DEA, the diversion of these medicines off from the path that they were on. Importantly, these opioids this is not a defective drug case. Our firm has handled, along with Weiss Luxembourg and David's firm, literally hundreds, maybe thousands of defective drug cases where a drug does something wrong and the consumer or the patient is not informed of that potential risk. This is more of these drugs are doing exactly what they were intended to do. It's much more of a deceptive drug case and a defective drug case. And I think Commissioner Whitaker, you asked the question about the physicians that are involved in prescribing these medicines and what is the liability with them. One thing that the opioid manufacturers and distribution companies really did two things at the same time that relates to the conduct or culpability of the prescribing physicians. On one hand, they reduced the perception of addiction related to these medicines. There are videos, there are materials produced by these distribution companies. Every firm involved in this case has these, and we will obtain more of this, where they said, these drugs just aren't addictive. These drugs are safe. Claims of their addictive properties are overstated, et cetera, et cetera. All facts that were known at that time to be untrue by certainly by the manufacturers and the distribution companies. The second thing, and while they're doing this, while they're taking the brakes off, if you will, among the prescribing physicians, they're also putting gas on the fire at the same time by saying, prescribe these medicines. They were intended initially to be medicines for two really narrow categories of use. One, post-surgical acute care pain management, essentially in-hospital type of care. And second, for palliative, in many respects, end-of-life, cancer-related or other terminal condition pain management. They were not supposed to be used for root canals, for example, or abscesses, for example. We know now that the addictive properties of these medicines can attach to a patient within 7 or 8 days, yet people were being discharged with a 30-day supply, for example. So this is a case about really irresponsible corporate behavior that has just washed down the river into Eaton County, into the city of Lansing that we represent, into counties across the state, and counties are beginning to hold this behavior accountable. I'm going to stop or pause, ask Paul to come up and continue to talk perhaps more about the litigation strategy that's unfolding. And I would obviously really thank you for your time today.
Right.
Paul?
Mr. Bernstein, the opioids we're talking about, are those all generic at this point?
No, so that's a great point, a good question. These are drugs that are, first of all, there are no Michigan defendants in this claim.
Okay.
The claim is against currently the distribution companies, some of whom, as I think Rob indicated, are enormous corporations, one of which, McKesson's the fifth largest company by market capitalization in the United States. And the pharmaceutical, the drug manufacturers. Some are generic, some are not generic. They're all tangled up in this claim. So, does that answer your?
Right, and the litigation that you're contemplating or already becoming involved in, that has potential probably to be equal to or greater than the tobacco cases that we hear about?
Well, the tobacco litigation was, and I can let Paul address this in greater detail, but the tobacco litigation, many people are calling this, I don't know if this is necessarily accurate, but consider this to be tobacco 2.0.
Okay.
Some of the there are many similarities to it, but it is not identical at all. But it's worth noting in one way, the lessons learned from the tobacco litigation with respect to counties and cities speaks in favor of you as a county, this county, pursuing this claim independent of the state. You'll recall in the tobacco litigation, which resulted in approximately a $3 billion recovery for the state of Michigan, none of that money trickled down to counties or cities. The state legislature in Lansing, I'm oversimplifying here, but essentially hocked that money
Right.
and took less than we were supposed to get the money immediately, very short term in that regard, and the money never got to the counties. And so that is one of the reasons why many counties we're talking to, I'd say all the counties we've talked to, and cities, have concluded, if they decide to pursue this claim or see merit in it, that it's essential to do this independent of the state. And there are other reasons as well why that's, I think, and we think, of course, that that's the right path forward. Sorry for the long answer. But
Right, and I appreciate that. If the county does become involved in this, there's probably no theory that you think is serious by which the county could become a cross-defendant in any way.
I would let Paul address that, but I don't see that.
Okay. Okay, thank you.
Good morning. My name's Paul Novak. I'm kind of the third leg of the triumvirate for the team that's presenting today. There's been reference to consortiums of lawyers. The consortium of lawyers that we're presenting to you are all represented here this morning for our side. It's Mr. Middleman here locally, Mr. Bernstein on a statewide basis, and our firm, Whites and Luxembourg, which is a national firm based in Manhattan, but I run an office in Detroit on behalf of the firm, and came to Whites and Lux because I was interested in just this type of national litigation. By way of background, however, I spent 20 years of my life in Lansing, working for the Attorney General's office. Was actually an elected official back in the mid-90s when Dave Hollister was elected mayor of Lansing. I was elected on the city council at the same time and served with him. And I had an opportunity to do this type of litigation, that is litigation against pharmaceutical companies, when I worked as an assistant attorney general for the state. We had a number of cases that addressed either fraudulent practices or antitrust behavior, or other types of illegal conduct engaged in by pharmaceutical manufacturers. And in each of those instances, when I was involved with the state, we worked in conjunction with state attorneys general around the country. And in fact, I served on the National Association of Attorneys General Prescription Drug Pricing Task Force to get recoveries not only for state governments, but in many instances for consumers. For example, we coordinated on behalf of all 50 state attorneys general the litigation against Hearst, Marion Roussel involving the drug cardizem CD, it's a heart medication, and obtained a recovery of $80 million that was distributed back to consumers who had been overcharged for those drugs. Similarly, we had actions back in those days involving Ativan, which is also known under the generic name lorazepam, obtained a recovery for consumers of about $100 million. Similarly, Buspar, an antidepressant medication, another $100 million recovery. And in each of those instances, we worked collaboratively as teams of assistant attorneys general that coordinated our activity between AG's offices across the country. I envision this litigation proceeding similarly. Commissioner, you asked whether we were in competition with the Summer Schwartz Group. We are for purposes of this representation. At the same time, however, the consortium with which they are a part and our group, I envision, and that consortium includes Barron and Budd and some other national firms that we work with on a regular basis. I envision that at the end of the day, those different national firms are going to be working with each other to take on the pharmaceutical companies and the wholesale distributors in this litigation. So even though we are competing for your business at a higher level, we're going to be working together and coordinating theories and reviewing discovery and doing all of the types of coordinated steps for a whole group of counties and municipalities across this country for purposes of obtaining a recovery and for reforming the practices that have led to what is the most grievous national epidemic drug-wise that this country has ever seen. I'm not going to repeat that the problem with going last is everyone stole all the statistics I was going to use. I'm not going to say steal because they obviously have access to the same material. But there is one statistic that hasn't been stated this morning that I think is one of the most compelling of any of the ones I've heard. And that is for any individual who has taken a prescription opioid product for 8 straight days, 13% of those people will continue to be on the same prescription opioid product a year later. And when you talk about, for instance, in the state of Michigan, over 1 million opioid prescriptions that have been written in this past year, and think about what 13% of that million prescriptions means, what that means to your county, the numbers are staggering in terms of how many people can be hardcore addicted in a very brief amount of time to the types of opioids we're talking about, and the different causes of action that we would envision bringing on behalf of the county really kind of focus on 2 basic types of conduct. The first is conduct related to deceptively marketing the non-addictiveness or downplaying the addictiveness of these medications, which a number of the pharmaceutical manufacturers clearly did starting in the 90s, resulting in the explosion of prescription activity that we've seen over the last 2 decades. The second set of conduct isn't so much the deceptiveness of the marketing and the downplaying of the addictive qualities of the drug, but it relates to the obligation, the statutory obligation imposed under both federal and state law for anyone in the distribution chain of these drugs to report activity if they know or have reason to suspect that either the drugs are being diverted or illegally prescribed in what are clearly inappropriate situations. It's already been mentioned, we've been retained by the city of Lansing, and the city of Lansing has been very aggressive in criminally prosecuting and convicting a couple of prescribers of opioid products, physicians in the Lansing area. I know without even looking that some of those prescribers will have written prescriptions for patients here in Eaton County. And one of the things that we're going to do, because those prescribers also would have had visits from pharmaceutical sales representatives, and I will guarantee you that the pharmaceutical sales representatives, when they walked into those offices, knew the volume of prescription activity that were being written over and over and over again out of those offices. And that is the second aspect of what we will be including in our lawsuit. Not only conduct relating to deception about the non-addictiveness of these drugs, but the second aspect would be illegal conduct and failure to report instances where you know that there has been overprescribing activity. And we've already traced that to a couple physicians in Lansing who've been criminally prosecuted successfully and who we suspect will be able to show a paper trail back to pharmaceutical sales representatives who, for all I know, probably got paid bonuses out of those physicians' offices because they were actually prescribing at a higher rate. Those are the types of theories that are going to be involved in your lawsuit. In terms of damages, we've seen in counties throughout the state increased incarceration costs, the increased naloxone or Narcan costs that your sheriff and any of the emergency responders are confronting when they have to visit someone who has overdosed on the drug. You're going to have an increase in mental health costs associated with the treatment of addicts. Those are only a couple things. We talked to Ingham County, and one of the things that they identified is that their contract with Sparrow Hospital had to be redone. They had a $250,000 cost overrun just attributable to the increased number of autopsies they had to perform. So there are a whole array of different cost increases that we're going to go after on behalf of the county if we're able to, or if it's determined appropriate for you to retain our group. And we feel that between the local presence with David, the statewide presence with Mark, and our firm at a national basis, but also even though we are a national firm, I'm from this area, I've spent plenty of time in this area. I sat through the 7-hour football game on Saturday. and we feel that we know this community and are able to represent it. So unless you have any questions, that's all I have.
I have just a couple. I'll defer to Blake. I've asked several.
How many clients have you thus far signed up?
We've got Lansing that has signed up. We have several who we are have been told we are going to be signing with, but haven't actually inked the retention. We're just talking Michigan. And so I'm not really authorized to disclose them yet. But I anticipate that we're going to have several, if not dozens, in the state.
Thank you.
And I have a question. This is all at this point contemplated to be federal litigation. Would it be appropriate to characterize this as a class action lawsuit?
I don't think it's going to be brought in a class capacity. I've brought class cases on behalf of the AG and since leaving the AG's office, but I think this is probably going to be more what I characterize as a mass tort. And the difference is that, like class cases, there are going to be thousands of lawsuits, but instead of having one class representative or a couple of class representatives on behalf of all of them, I think what is more likely to emerge in this instance is that there will be a host of communities across the country that sue, and then bellwether trials of a handful of those would be tried through to a verdict. And that will inform the parties as to how the lawsuits in total should be handled once a few trials actually are underway, litigated, and brought to a conclusion.
So if this comes forth as what you're characterizing as a mass tort cases, individual plaintiffs can settle, opt out prior to the complete end of the litigation?
Yes.
And I guess the final question, because bureaucrats and elected officials always smile when somebody mentions other people's money, the time frame or window for this type of litigation is certainly potentially very long. On a best litigation strategy possibility for settlements or whatever, we're talking about results that are 2 or 3 years down the road, or are we talking about the possibility of resolution prior to that time?
I'd be shocked if it was prior to that time.
Okay.
I think it's 2 to 3 years there is an emerging national consensus that this is a crisis.
Right.
And that may cause things to move sooner than they otherwise would. At the same time, our firm has been engaged in cases where it might take a decade to resolve. And one of the benefits that we bring is we have resources sufficiently so that when the other side says we can just string this out and eventually they'll get sick of it or they'll run out of money, we have been successful enough that there is not I think defense counsel understand that we're still going to be here even if they do string it out for 10 years. And so the success of that strategy is kind of taken off the table.
Right, and this is not only a political litigation, it's a big dollar litigation. Do you anticipate the U.S. Department of Justice trying to get involved in the litigation that you're talking about?
DOJ has brought, and the folder that I left makes reference to a few different settlements that have occurred over the last decade.
Oh, okay.
Resolving certain components from a federal perspective, some of the issues that have been in play in this lawsuit, specifically as it relates to distribution practices by the wholesalers. Some of those resolved cases didn't specifically address opioids. I think 1 or 2 did. But this thing has been attacked on a few occasions, both from the Department of Justice and from a number of state AGs. There has been a settlement, for example, with West Virginia and Purdue Pharma, one of the manufacturers. Kentucky and some of my friends down in the Kentucky Attorney General's office have waged some successful litigation. So there have been little bits and pieces here and there, but nothing that is as overreaching to try to deal with the entire national epidemic as we think this next round of cases are. The one thing I failed to mention, there is on November 29th a hearing in St. Louis that will 30th. I always go to the dinner the night before.
Oh, is that it?
It's good to be invited.
And the importance of that hearing is that it will select one federal district around the country where all of these suits are going to be consolidated for purposes of pretrial discovery. And we think that might end up being consolidated in Columbus, Ohio, maybe the Southern District of Illinois. There are a couple of other cases where they could be consolidated, but it's our anticipation that all of the national cases are going to be consolidated in one federal district court so that discovery over the entire overarching issue can be coordinated in one proceeding.
Right.
Thank you. We are running out of time. Overtime. Thank you.